Hey everyone, and welcome to This Explainer. Today we're unpacking a legal drama that is just absolutely fascinating. We're looking at a landmark 1997 South African constitutional court case that struck right at the heart of a newly democratic nation. It literally pitted the massive, sweeping powers of a president against one of our most fundamental human rights, the right to equality. It's this incredible story about mercy, parental rights, and a fiercely debated legal question about what true equality actually looks like when you put it into practice.
Okay, let's dive right into this by putting ourselves in the shoes of a guy named John Hugo. So, it's 1994, and Hugo is serving a 15-and-a-half-year prison sentence. He's also a widower, and he's the father of a young son who was born back in 1982. Now, just imagine Hugo's reaction when he hears the news that the president has just issued a special pardon, releasing prisoners who have children under the age of 12. I mean, it sounds like an absolute miracle, right? But there's just one catch. The pardon specifically states that it applies only to mothers in prison with minor children. And because John Hugo is a father, he's left behind bars. That single specific distinction sparks this monumental legal battle. Because you have to ask, if mothers are free to care for their children, shouldn't fathers be freed too? So here's our roadmap for This Explainer today. First, we'll look at the 1994 presidential pardon. Second, can the court intervene? Third, the equality dilemma. Fourth, the majority ruling. And finally, a powerful dissent. All right, jumping right into part one, the 1994 presidential pardon, a celebration of democracy. Picture the scene. The date is May 10, 1994. This is a day of profound, massive historical significance. It's the inauguration of South Africa's first democratically elected president. And to celebrate this huge milestone, and really as a profound act of mercy, the president signs what's known as Presidential Act No. 17. This act grants a special remission of sentences to certain vulnerable categories of prisoners. We're talking disabled prisoners, young people, that sort of thing. But the specific category that triggers our whole case today is this: all mothers in prison on May 10, 1994 with minor children under the age of 12. Meanwhile, fathers in the exact same situation, they received absolutely no such pardon. John Hugo argued that this was a glaring violation of his constitutional right to equality, and well, he took the president to court. Which brings us to part two. Can the court intervene? Challenging the president.
Now, before a judge could even look at whether this pardon was fair, they had to answer a pretty massive constitutional question. Does the judicial branch even have the authority to review this specific type of presidential action? To really get the government's defense here, we have to talk about this concept called prerogative power. Historically, the power to pardon a criminal was a non-statutory power. It belonged to the English monarch. It was basically an absolute act of royal grace. The South African president actually derived his power to pardon from Section 82 of the interim constitution, which had essentially inherited these historical head-of-state powers. So the initial argument was basically, hey, because pardons are executive acts of mercy, they should be totally immune from being second-guessed by judges.
But the South African Constitutional Court didn't just look inward. They looked globally to see how modern democracies were handling this exact issue, and they found a really clear trend. In the UK, courts had started reviewing prerogative powers if the subject matter was deemed appropriate for courts to handle. Over in the US, the Supreme Court ruled that while the pardon power definitely has those royal roots, it flows from the Constitution, meaning it cannot offend other constitutional rights. And courts in Canada and Germany, they'd reached very similar conclusions. So, based on all of this international consensus, the South African court ruled definitively. They said the president is a servant of the Constitution. Therefore, his power to pardon is absolutely subject to the discipline of the Bill of Rights. Boom! The court had the green light to intervene. So we move into part three, the equality dilemma. Good intentions versus the Constitution.
The absolute cornerstone of John Hugo's entire argument was Section 8 of the interim Constitution, the Equality Clause. Now, Section 8 explicitly states that no person shall be unfairly discriminated against on the grounds of gender or sex. But it goes further than that. It contains this incredibly powerful presumption. If a law or an executive act discriminates based on gender, it is automatically presumed to be unfair discrimination, right off the bat, until proven otherwise. Since the presidential act so clearly treated men and women differently, that burden of proof shifted entirely onto the president. He was the one who had to prove to the court why leaving those fathers in prison was actually fair. Now, the president's defense was deeply pragmatic, and it was entirely focused on the kids. He actually submitted an affidavit stating that his primary motivation was just a deep concern for children who were being deprived of nurturing. And to back this up, he provided testimony from Helen Stark, a child welfare director. She stated that the primary bonding with the mother and the role of mothers as the primary nurturers and caregivers extends well into childhood. So the president argued that to quickly and effectively serve the best interests of these vulnerable kids, he simply targeted the group that was most likely to be their primary caregivers, mothers.
But, this brings us to a really fascinating paradox, and it's one the judges definitely highlighted. The president was relying on the fact that women carry an unequal burden of child-rearing in society. But isn't that very fact a root cause of women's inequality in the first place? By rewarding this societal norm with a pardon, you have to ask, was the president actually reinforcing a really damaging stereotype that a woman's place is in the home, raising children? It's like a giant legal puzzle, and this is the incredibly tightrope the Constitutional Court had to walk. Let's see how they handled it in Part 4, the majority ruling, the pragmatic choice. Now, what's really interesting here is the sheer logistical reality the president was facing. Judge Goldstone looked really closely at the actual facts of the prison system. In 1994, the daily average prison population was 108,066 males, compared to just 2,867 females. Let those numbers sink in for a second. To put that into perspective, women made up only 2.58% of the entire prison population. Judge Goldstone pointed out that the president was acting in the public interest here, and the public interest includes maintaining the integrity of the judicial system and managing the public's very legitimate anxiety about crime. Think about it. If the president had been forced to release all fathers of children under 12 just to avoid gender discrimination, he would have been releasing a massive, completely unmanageable number of male prisoners. The resulting public outcry over crime would have been an absolute disaster.
So Judge Goldstone concluded that the pardon was essentially a wholesale act of mercy. Look, it was a blunt instrument for sure, but drawing a line always leaves someone on the other side. Yes, it relied on a generalization about mothers, but in this very specific, isolated context of a presidential pardon, a situation where no prisoner has a legal right to be released early anyway, the discrimination wasn't actually unfair. The fathers weren't being deprived of their liberty by the president. Their liberty was restricted because of their original criminal convictions. As Goldstone wrote, it did not fundamentally impair the fathers' rights of dignity or their sense of equal worth. And with that, the majority upheld the pardon.
But not everyone agreed. And that takes us to Part 5. A powerful dissent, and the dangers of stereotyping.
Judge Kriegler fully acknowledged the president's good faith and his genuine desire to help these kids. But for Kriegler, the Constitution's demand for equality was absolute, no exceptions. He argued that the South African Constitution is fundamentally egalitarian. It's designed to eradicate past discriminations. By officially acting on the stereotype that mothers are the natural childminders, the state was legally validating the exact patriarchy that keeps women occupationally inferior and heavily burdened. Kriegler argued that you simply cannot justify a constitutional breach by pointing to administrative convenience or the fear of public outcry. For him, the presumption that the gender discrimination was unfair had not been rebutted. He ruled the act was unconstitutional.
Ultimately, though, the majority's view prevailed. The resolution of the case was that the pardon was upheld as a constitutionally valid act of mercy. The court recognized it for what it was, a blunt tool that utilized a societal generalization, but they ruled that in the context of a one-time executive pardon aimed at the welfare of children, it didn't actually cross the line into unfair discrimination against men. And this judgment really matters today because it remains this profound exploration of how our highest constitutional ideals sometimes have to wrestle with stark, messy societal realities.
Which leaves us with this final, really provocative thought to ponder. The Hugo case forces us to ask a tough question. Does true equality under the law require us to treat absolutely everyone exactly the same, remaining completely blind to gender? Or does justice sometimes actually require us to acknowledge the deeply entrenched societal realities and burdens that differentiate us? It's a heavy debate, and one that extends way beyond the walls of the Constitutional Court. Thank you so much for joining me for this explainer. Keep questioning the world around you, and I'll catch you next time.